So what we are going to do today is we try to engage you in part of our session, okay? And if there's any part you want to stop us, ask question, by all means, let's do it. This is 101. We want to hear from you. We also want to learn from you, and we hope to give our 5 cents worth of legal assistance. All right. Now, I was actually asked to say, hey, Cyril, are you interested in Legal 101 for charities? I say, yeah, sure, I would like to attend and listen. And they said, no, Cyril, you've got to go and present. I was like, gosh, I should be listening and not presenting. So I found the best candidate, and that's Juliana. And Juliana is the chairman of Project Law Help, which is part of a Law Society pro bono initiative. And Project Law Help is here to specifically help charities and VWOs. So without further ado, I'll let Juliana introduce herself and also Project Law Help.
Okay, thanks, Cyril. Project Law Help. I thought we have some slides here to tell you a bit about what Law Society does with regards to pro bono services for community organizations. Okay. So the Law Society of Singapore actually administers quite a lot of initiatives towards assisting the public access to justice. Okay. Part of these initiatives include help for community organizations, and these include charities, NPOs, VWOs, social enterprises. We actually cover quite a lot of different, areas of help. The first among, all these pro bono corporate legal assistance. PLH, Project Law Help, is actually one of the initiatives. We also have clinics that are run for community organizations. And these are just some of the examples of the kind of legal advisory work that we can help community organizations with. And I'll just leave that slide there for a while because there's quite a lot of information over there. And then it might actually just, jog your memory about, kind of things that, you yourself in your charity might actually, want to approach Law Society, the Project Law Help for. Okay. Okay. Just highlighting two of these initiatives for community organizations. We have this thing called community organization clinics. These clinics are actually designed for very short sessions, 45-minute sessions, one-to-one, between a charity and a volunteer lawyer. So it's designed for actually basic legal advice. If you have a legal question, you need a quick answer that can be covered in a 45-minute session. This is the platform for you to think about community organization clinics. Okay, and we also have, this is Project Law Help. And what Project Law Help does is actually we do a match-up service between charities and volunteer law firms. So once the match-up is done, basically you have the law firm will actually deal with you directly on a normal solicitor-client basis. Okay, the only difference being that the services are provided pro bono, so free of charge. They don't charge you a legal fee for it. But we do have a means and merits test for this matching service because it actually covers usually a longer period. It's more than the 45-minute basic legal advice. It can actually cover something that is longer, like maybe possibly even, say, if you wanted to convert your organization from one entity to another entity, say. So that could take a bit of time and more legal work than just say something that could be covered in 45 minutes. So that's a PLH. Some of our publications, we've uploaded it on our website. So this is useful to know. You can just actually go to the website. It's free, and you can actually look for the information in these publications. We have hard copies of them as well, but it's available online. And finally, how to contact us. Somebody was actually asking me, how how do I find you if I need, to attend a clinic or, be matched up with a volunteer law firm? It's all here. And I think the slides will be made available to you as participants, right? So good to keep that. Or you can take a picture of it. Okay? So this is where to find us. Okay, now to the stuff of the workshop. So Cyril and I, through the work that we do with community organizations, we found that probably the top three areas to do with the law that community organizations or charities seem to grapple a lot with legal structures, conflicts of interest, and personal data protection obligations. Personal data protection is actually, is quite a fairly new area. This seems to be the top three areas. So this is what we will cover in the workshop. And as Cyril says, as we go through the material, some of them might be a bit heavy going or boring. Feel free to stop us and ask questions along the way.
Or we will ask questions,
Or we will
Juliana.
ask questions.
Yeah.
Yeah. Do we have a name list?
Unfortunately, they hid it from us, so we will have to.
Point.
Yeah, part of PDPA perhaps.
I see.
But we'll go around and we will hope to ask questions to keep everyone a little bit more alive and awake.
Yeah.
We think it's necessary.
Okay. So the first area that we would topic of our workshop is legal community charitable organizations and legal structures.
Okay, maybe I'll
Okay.
just start a little bit before Juliana goes ahead. Is that, see, a lot of us are either societies or CLG, and I think there are a lot of thoughts as to societies converting to CLGs or why CLGs should we function better as a society. And for all that, maybe we'll just let Juliana explain to you what are her thoughts. Yeah.
We'll actually come to conversion of the a legal structure from one form into another form somewhere down the line. But maybe before we do that, just before we do that, I just wanted to put something up so that we know we're all on the same page as to what we're talking about when we are referring to legal structures. Legal structures is actually an old nut. There's really nothing new going on in this area. It's just basically the form in which a gathering of individuals and their goals and activities are united as an organization. And this form provides the organization with its legal existence and recognition by the world at large. So the legal structure is what facilitates your work and your relationships with other organizations, with third parties, your vendors, your donors, etc. Okay, so this is what we're talking about, basically, when we're talking about legal structures. And there is a fair bit of jargon involved in the horizon. And I know that, this is after lunch session. There's also a bit of can get a bit technical. So technical meaning that it's possibly sleep-inducing. So if you guys, especially if you are suffering from, the after-lunch stupor, I know about that. I hope I don't fall asleep. But, if you feel that you can't keep your eyes open, that's okay, we won't hold it against you. But, one of the reasons why we, this is not the only reason why we put the legal structures as the first topic in our workshop. It's very important. It's important when you're starting up a charity. It's important as you go along when you consider, to convert maybe from one legal entity to another entity. It's important, but it's another reason why we put it first, right after lunch workshop, is if you can't keep yourself awake, it's okay. But we do like to keep our audience fresh and awake at the end, for the applause. I mean the Q&A. Okay, so we'll just start with, maybe I'll just tell you what are the legal structures, okay? You'll be thinking, what are the legal structures? And there are a couple that charities in Singapore need to know about. In other words, these are the typical legal structures that charities in Singapore will adopt. So these are the companies, the society, and the trust. Okay, we will also be covering choosing a legal structure, changing legal structures later on. So at this point, I guess I can assume that everybody everybody's here represents a charity, right? Charities represent a charity. Anybody here doesn't represent a charity? Oh, okay. You can say it's okay. Okay, but most of us are from charity, so you would be one or the other, usually, I would think. But we'll ask you that later on. So you have companies, and then you have societies, and you have trusts. So what are companies? And this is the part that gets a bit, technical. What are companies? Do we know what companies are? Anybody wanna, apart from what's on the slide, because then that will be cheating. What do you know about companies? Anybody want to? Too bad we don't have the name list, right?
Yeah, unfortunately. Yeah.
Oh, but we know Yiming though.
Yeah. Yiming?
Sorry. Yeah, what do you know about a company? What are the feature? What is the feature of a company? Yeah. Yes. Yeah. 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 That's basically it. It's a body corporate. It has a legal personality. It's a separate legal personality from its members. So, which means that it's literally a legal person. A company is literally a legal person, and so that means it can own property in its own name. It can also sue and be sued in its own name, and it's also one of the very important feature of a company is this thing called limited liability. When you look at company names, you always see the word limited in the company name, right? What does it signify? It's not limited liability of the company, but it's limited liability of the members. And this is very important. This is one of the main reasons why people incorporate at all, because the members have limited liability. Yeah, I think a lot of you probably know that already. Then we have different types of companies. So a company can be limited by shares or limited by guarantee. In the context of charities, usually we're talking about a company limited by guarantee or a CLG, right? Between the two types of companies, CLG and companies limited by shares, the more common or the more ubiquitous one you see in the marketplace would be a company limited by shares. Private limited company, the members are shareholders, so they own shares in the company. CLG doesn't have shareholders. It's limited by guarantee. Okay, and I just wanted to also, because we needed to do slides, and so I wanted to make sure that the stuff that are on the slides, which you will take home, are things that you can keep and as souvenirs and it's useful as well. Okay, I've actually extracted two very important regulations that you find in a CLG. This is from the model constitution for CLGs. The first one is that the income and the property of the company must be applied solely towards the promotion of the objects of the company. And you cannot use the income and property, to pay the members by way of profit. And then the next thing is that if the CLG is wound up, after it's wound up, if there's any residual assets, those assets will go to a, charity or an IPC that's registered under the Charities Act, and having objects that are similar to the dissolved CLG, and it doesn't go to the members. Okay? Are we still all awake? Okay, not so bad. I hope. Okay, then we come to societies. Societies, just very quickly, what do you know about societies? Let's start with how societies are similar to companies. Do we know? Yes, it's registered under the Registry of Societies, whereas a company is registered with ACRA. Whether you're a charitable company or a non-charitable company, you all have to be registered with ACRA. But society is with Registrar of Societies. Society also has a lot of the similar kind of organizational hallmarks as a company. So it will also have no, actually it doesn't have a legal entity. Yeah. But, so it doesn't exist separately from its members. But what it does have is, some of the things that are similar to a company is that you need to have a place of business. You need to have a registered address where your books of account and your records are kept. Other than that, you also have officers. So in companies, you have directors. For societies, you have committee members. You have the president, treasurer, secretary, and so on and so forth. Then you also have the internal rules of the society. Like, sometimes it's called the bylaws or articles, or even a constitution, similar to a company. A company's internal regulations are called constitution. That's defined in the Companies Act. Anything else? Do you have to file accounts? Do you have to keep accounts? Yeah, you do. You have to keep accounts, and then you have to file annual returns, similar to a company. But what's very different between a company and a society is that, well, the regulatory compliance is actually quite different, and then, or the extent of the regulatory compliance for a company as compared to a registry, as compared to a society is quite different. So you can test it by weighing the respective legislation that applies to these to societies and to companies. So on the one hand, you have the Societies Act, which is the main piece of legislation governing societies, and it's 38 sections long. And then on the other hand, you have the Companies Act with 411 sections. So companies and societies. And then not to forget the subsidiary legislation as well. So you have the Societies Act with one regulation, one subsidiary legislation, and Companies Act more than 20 subsidiary legislation. So the difference is quite a lot, compliance. And it actually demonstrates the kind of accountability that, the difference in accountability between a society and a company. And I think probably the main reason for this is because of this concept of limited liability. The company exists separately from its members. So for third parties, creditors dealing with the company, it's important to have this kind of additional accountability. Okay?
So, Juliana, why pick one over another? Right? If it's so cumbersome to have a company limit like guarantee, why not just stick with society?
Well, good question. Any suggestions from the floor? This is one of the main areas that we wanted to discuss. Cyril and I wanted to discuss with you, because this is a question that actually a lot of charities will ask us. Should we incorporate? Should we stay as a society? There's one more entity called a trust, which we actually haven't talked about yet. But that's even simpler. What's a trust? A trust is created by a trust deed or a settlement. It's just a piece of paper setting up the trust. It has a charitable purpose, obviously, because we are talking about charities. And then the trust deed will appoint trustees that actually manage the trust. Very simple kind of organization. No separate legal entity. The trustees, it can't own its own assets. Trustees will own the assets legally, and they will be liable for all the liabilities of the debts of the trust. So, but why would you choose one entity over another? In terms of the legal considerations, we actually talked about some of them already. I think the main thing, the main thing for when you think about, whether I want to incorporate or not, what's the main feature is the limited liability. The members are not liable for the debts of the company. So it's risk mitigation, if you like. So when we come to the practical considerations and legal considerations, when you think about, should I incorporate, should I stay as a society, you actually have to think about, your practical situation of your organization. What are your activities? What's your operational? Do you have a lot of contracts? Potentially, are you contracting with a lot of third parties such that you may be sued on the contract? Do you need to own a lot of assets? Do you lease properties? Do you own properties? And then you match that to the legal considerations. We talked about regulatory compliance. If you're a simple small organization, then you might not want to actually grapple with the 411 sections and 20 over subsidiary legislation under the Companies Act. But limitation of liabilities usually is quite a big factor. Maybe at this juncture, what we'll do, as an exercise, can we have a show of hands? Anybody here whose charity is a company? Okay, why are you guys a company? Okay, limited liability. Anything else?
How many societies here? Okay.
A lot of societies.
More societies.
Why use society?
Easier. Maybe I'll just share a little bit on my experience. Right. Years ago, I joined Ang Mo Kio FSC. It was a society, right? In fact, some of the earlier administrative days, right, someone asked, do you want to be an annual member or a life member? I was like, life member? Life member means lifetime liability, right? So then we started looking at it when we, it was just a small group of members, and we look at it the work we do, we have back then it was about 50 to 60 staff. And then we have all these contracts, we have all these commitments, all these agreements and funding agreements we signed with NCSS, MCYS back then. And you kind of wonder, wow, should something were to go wrong, what happens? Then you look at it, it will be all the members who are part of society would be liable. And then you look at the membership list. It's been around, Ang Mo Kio had been around for 20 over years. And we have all these members dating back to 1976. And they are no longer really active in the society, and they would still be liable because they are listed as members of the organization, even though they have not come for a meeting for the last 15 years. Then you realize that, okay, we need to do something about it. And then we embark on the journey of converting it into CLG.
No pressure on societies or anything.
Yeah, no pressure, because you see, if your organization is quite small, you find that you can manage it fairly efficiently, why do you want to go into this CLG where you need to file your annual returns, you need to employ a corporate secretarial service, and you have not only account to the COC, you also have to talk to the registrar, the ACRA, to deal with two regulatory bodies looking at you, looking at your directors, whether are they in breach of fiduciary duty, whether they have breached as a role of trustee. So you find that there are a lot more people watching over you if you are CLG. But that is the transformation process. Sometimes when you grow, unfortunately, you have to also think of your members. If you tell your members, oh, now we are $1 million turnover organization, but if anything go wrong, all of you have unlimited liability. Someone can sue you and take away your home and all your assets. Then you're going to have a problem with succession planning. Who wants to join your society? Gosh, it becomes a bit more risky, right? Yeah. Juliana? What do you think?
So actually one of the practical considerations is what really are your activities. If not all organizations are set up to actually have situations where they incur a lot of liabilities or any liabilities at all. Like, say if you are a society that encourages reading books, for example, a society might actually be the ideal kind of legal structure for you, because you have members that are actually of a common mind. You probably only need to run by the monthly subscription or whatever, payments, membership dues that come from the society, and then you carry out initiatives, educational programs, and things like that. So not all kinds of activities of a charity need to actually consider liability as a big factor in terms of what kind of legal structure they should take. Some organizations are suited to remain as societies, and I thought I'd just say that because when you talk about liability, it's so scary, right? Yeah.
So how do we convert from a society?
So, if you do need to convert, or you're thinking of converting, then actually, the term converting is actually quite misleading. You can't actually convert a society to a company, or a trust to a society, or whatever it is. What happens is that you actually need to form your new entity. So if you're a society and your intention is to carry on as a company, what you need to do first of all is to form your company, your CLG. So you incorporate first, and then you will have two organizations existing at the same time in parallel. So you have the societies, and then you have the company, and then there will be a process of transferring over. So all the transferring over all the assets and liabilities from the society to your new company, and then at the same time your society will be winding down its activities, and then finally you have the dissolution of the society, which is a very simple thing. Unlike a company, with a society, it's just an act of will. You just need to get your president, treasurer, and secretary to sign a certificate of dissolution, file it with the registrar of societies. Make sure you actually comply with whatever bylaws that you have relating to dissolution. And then once the registrar is satisfied you've complied with all those, he will publish a notice in the Gazette, and that will be the end of the society. Yeah, and we're actually very lucky because Cyril here, who has personal experience with Amokyo FSC, which is now AMKFSC, Community Services Limited.
Maybe I'll just share with you my brief experience. We embarked on this journey of converting MOKFSC from a society to company limited by guarantee. And conversion is not like turning a cat into a dog or something like that. No, it's not even like renovating a house. It's more of shifting house. I like to look at it by way of analogy. So first thing is that we incorporate a company, and the company exists at the same time as the society. Then we realize that we got to transfer all the agreements from the society to the CLG, which wasn't easy because you have all the funding agreements. We need to talk to NCSS and say, can we novate the agreement from the society to the CLG? Then they said, okay. Oh, on top of that, before that, you need to get your CLG registered as a charity to get your IPC status, do everything all over again, right? And then we start getting all the agreements, and then some of the agreements look at it like, oh, funding period, 1.5 years. It's going to end soon, never mind. We will maybe finish this funding period, and then the new funding period, we get the CLG to sign. And then we find that along the way, we bumped into HDB. And HDB said, we told HDB, can we move the lease from the society to the CLG? And then they found that they're uncomfortable for whatever reasons, not comfortable. So we had to wait for the lease period to expire, and then we signed a new lease with the CLG. Yeah. So it takes time, and that took about 2.5 years before we managed to remove all the agreements, the employment contracts, everything into the CLG. When all is nice and clear, then we dissolve the society. So it's like moving house, right? Think of a very slow moving house process. Every week you move some things over and it takes 2.5 years. Then finally your old house has been cleared. You can sell it off. So that was the experience we had. Anyone had any experience of turning the society into a CLG over here? Okay. But having said that, it was a very, in Ang Mo Kio it was very easy because there were very few members. Now, if you have an organization with long history and many members, it becomes more difficult. Some members will say, oh, I like the society, it's got a lot of historical meaning, how we set it up, and then they refuse. Then you are stuck. You may transfer everything, then you find that the society is still functional, the members are still there, and it will still attract liability. So it's important to get all your members on board this transition process. Yes?
I just have a question. I'm not from a society, but is there any provision to protect societies who are transferring over to a limited company, that their society name, identity from the past is not taken by someone else once they dissolve?
That's intellectual property.
Yeah.
Right up Cyril's alley.
Okay. Unfortunately, there's no provision. But what happens is, if someone were to pass off their society as your dissolved society, you can still take action against them on the basis of passing off. But what I really suggest is go register a trademark for the work you do.
It doesn't really apply to me, but if I'm looking at a society that is wanting to limit their I'm just saying that if I'm a society and I'm wanting to limit my liability, I would be concerned about that, especially if I have a long history.
Yeah.
Sure. So register a trademark of the name of your society, or at least, so let's look at the Ang Mo Kio Family Service Center. What's known in the market is AMKFSC, right? And I think that would be a nice trademark to register to ensure that there's no one who would try to use the same mark in relation, or the same name in relation to social services.
Does that answer your question?
Okay.
Do we have any other questions?
Okay, one moment. Sir, you are?
My question is, can a society, also a charity, hold property?
Well,
Or any restrictions?
Well, okay. So coming back to what is a society actually doesn't exist apart from its members. It's unlike a company. It doesn't have a legal personality. So technically, a society cannot own property in its own name. You will usually own a property through a trustee. I think in most the context of the charities in Singapore that are societies that need or that do own assets and property, you actually own it through a trustee. Answer your question?
Yeah, you're owning the property through your members. Yeah, in that sense.
The legal title will be, in a trustee or through your members. Okay. Any other questions?
Okay. If not, let's go to the next section, which is
yes.
the conflict of interest, because we need to keep the time schedule.
Okay. So conflict of interest. Okay, conflict of interest is actually this is what we're going to cover, and okay, does everybody here know about the COG, the Code of Governance for Charities and IPCs? Everybody's familiar with that, right? Yeah. Okay, good. Because you have to do your first filing soon, right, of your GEC. The COG. The Code of Governance for Charities actually sets out a definition of what is a conflict of interest. A conflict of interest is a situation where a board member, staff, or other person has an existing, I think there was a typo in the COG, so I've put it in square brackets, has an existing or potential financial or other material interest that might impair his or her independence or objectivity in the discharge of responsibilities and duties to the charity. How does this usually manifest itself? You know, okay, this is a conflict of, how does it manifest itself in reality? One of the ways in which it commonly manifests itself is where a board member, a staff, or other person is in a position personally, or somebody who's connected to him is in a position to benefit from a decision that is being made for the charity. And a connected person can be, family member, relative. It can also be another charity or another organization which that board member or staff controls or owns or influences. So that's one way. Another way is, you have a situation of conflict of loyalty. So you have a board member of charity A who's also a board member of charity B, So there's a conflict of loyalty. A situation could arise where you actually could have a decision whereby, if you make it on behalf of this charity, it could also affect the other charity, or, if you do something here, it could also affect that. You can't be objective. Whose side do you take? A conflict of loyalty. And then connected with that also is that, sometimes you can be put in a board member or a staff or other person can actually be put in a position where, a conflict could arise. So somebody comes and, gives you a gift or some kind of hospitality, a trip somewhere, in order to influence your decision. So obviously, if somebody comes up and with a gift or hospitality to influence decision, that should never be accepted. So these are the kind of situations how a conflict of interest arises. We'll go through some
Sure.
examples later on.
But maybe you can explain why is it important if following the COG is not really compulsory?
Yeah, actually, I was going to ask you that. So, why is it important for us? Why is conflict of? It's actually a duty to avoid conflict of interest. What is conflict of interest? Actually, this area is you have a duty to avoid conflict of interest. And why is it important for you to avoid a conflict of interest? It's because if you have a conflict of interest, it can lead to these kind of bad things. And then the last of which is related to your question, is the legal consequences to the person involved. So the COG is not mandatory. We all know that. It's comply or explain. But conflicts of interest actually has legal underpinnings as well, and that's another reason. That's one of the reasons why it's important. And Cyril, I was hoping that you could go through.
Okay.
That part.
Maybe what I'll see. The thing about conflict of interest is a concept, and then you find that there are a lot of various scenarios that may take place, and sometimes you're not very sure is that a conflict or not a conflict. But let's try to run through some scenarios, right? Assuming I'm a small charity, and small charities, you always rely on help from friends in donation or in kinds. And for example, I might be going to throw an event, and I say, okay, I need catering services. What's the easiest? Oh, my father's a caterer. Why not just engage him? So easy, just one phone call. Pa, I need food. Can you bring over whatsoever? About expecting 50 people. $5 per head count, can? I'll say, oh, can. Okay, fine. What do you think? If I'm a director of a charity, can I do that? Is there any conflict? Yes. Very clear, right? Very easy, because you know that that's your father. Your father, your own family member has a potential financial gain. Even though your father may say, hey, $5 per head, I lose money. You can't do that. But the fact that there is a conflict, or at least there seems to be there's a potential conflict of interest, you avoid that. You don't engage your father. You don't engage your family members for any jobs of such nature, outsourcing jobs of such nature for a charity. So say we twist it around. Sorry, you're from?
SIF, Singapore.
Okay, so you're not charity. You're not part of the charity, right? Okay. You're from the foundation.
Yeah, foundation.
Okay, all right. So assuming SIF, all right, and you're now branching into actual social work on the ground. And say you're a director, one of the directors of SIF, and your sister, who is a social work graduate, would like to apply for SIF, what would you advise her?
Sorry, what was?
If your sister, your family member, who wants to apply as a social worker for SIF, what would you advise her?
To apply directly.
Okay, apply directly through the proper channel.
Relationship.
And declare relationship.
Yeah, because usually you have to like, in the application form, you will be asked, do you have any existing relationship with the place you're applying for, right?
So, all right, so she makes all the declaration, and then assuming that you're in the panel to decide on her application, what would you do?
I believe that I'm not supposed to.
You're not supposed to, but you're on a recruitment drive and you're the head of HR, and you're supposed to get in 3 social workers, and one of the application is your sister's application. So what would you advise? What would you do?
I guess I have to abstain from being part of the decision making and hiring of the particular position.
Brilliant. She got it right. So if you sense that there's an issue of conflict of interest or potential conflict of interest, you disclose it and you abstain from decision-making process. Now, I always run into this issue of conflict of interest, partly because of the number of hats I wear. I sit on the board in NCSS. I sit on the board in the Law Society Pro Bono Services. I sit on the board for the Special Needs Trust Company. I sit on the board of Ang-Mo-Kio FSC. I still remember in one of the incidents in NCSS, there was Ang-Mo-Kio FSC as well as the Law Society applying for CFS space in Chinatown Point. And then as NCSS, I sit there to make my recommendation. And I was like in triple conflict, So what do? You declare a conflict and you said, I'm sorry, I have to abstain from even the thought process of debating the merits of each of the application. So abstention, declaration and abstention is key.
Yep.
Okay. Any other questions? Anyone?
Sorry, just an extension from your example of your dad being the caterer. So in the event that if we recognize this as a conflict and we get 2 other quotes, for example, who's charging us like $25 per pax, and your dad's charging us $5 per pax. So if we do proceed with your dad, that's a managed conflict of interest, right?
Okay, in some sense, yes, the managed conflict of interest, but the concern is always like the other 2 caterers who have lost out on the procurement process may say, hey, dad has inside information on how much they tendered for. So in such cases, we generally would recommend that the family members should not participate, if possible, right? I mean, you can still disclose, right, to the board that, look, I'm an interested party. My dad is part of the party who tendered for the project, for the catering, and I do not wish to be part of the decision-making process. You could do that, but the concern is always someone has received some insider information on the procurement process or the tender process that would give that particular person undue advantage.
But if you manage that such that this individual does not get insider information.
Yes, that would help to address to some extent. But conflict of interest is not just actual conflict, but potential or perception of conflict. Because one of the points which Juliana highlighted correctly is you need to manage reputation, right, of the organization. You wouldn't to be associated like, oh, that organization, he gives his father this, he gives his mother that, and brother and sisters get a particular deal. So that is the part you need to manage. And unfortunately, in the charity sector, sometimes we all started that way. I mean, we always rely on our friends, our family members to give us licks up or a hand in this and that. And over time, we tend to rely on them to help out in the charities. But as you grow, you find that you move into this dubious area of conflict of interest. And we always recommend not to get your family members involved. Okay, thanks.
But if you know that, Like in your example, yeah, if you know that the $5 really is not even market rate, but lower the market rate, would that not kind of provide justification for the board to make the decision to go with the $5?
To some extent, yes. But the point is, people will start qualifying about the quality of the food and a whole lot of issues. Now, see, there are arguments on both sides, right? And at the end of the day, you can probably still justify a position. But my point is, why go through the hassle? For those people who do not know the actual facts, they'll say, Cyril awarded the contract to his own dad. And that's all they remember. And then they will be... and these may be raised in years to come. So as a matter of prudence, I generally recommend not to. Sorry, you have one more question there. Can I take the gentleman first? Yeah, sorry.
No, I refer to the earlier question where if there's a conflict of interest, you declare it and you abstain from discussion on the matter. In some instances, after declaration, the person is required to leave the meeting because you should not be a witness to what the other members say and how the other members vote. So to abstain is not good enough. The person must leave the meeting while the item is being discussed. Thank you.
Yeah, that's actually the position under the COG. If board members are required to, if a board member potentially is in a conflict of interest, he cannot participate or vote in the decision making. So that's a good point to make. Yeah. So the kind of steps that you take, and that's part of what you brought up about managing conflicts of interest. Managing conflicts of interest is important. Maybe we'll go to the question first.
Oh, okay. Maybe a quick comment to that gentleman. I think he's perfectly right. You should leave the meeting because we've looked at this before, and the right thing to do is leave the meeting. Otherwise, you still have a conflict. So his point is perfect. The other point was actually you need to look at the policies and procedures, because your policy and procedure will dictate whether you need to go through a small purchase, small value purchase, or ITQ. Because if you just take one quote, how do you know it's fair? Because you don't have any basis for comparison, right? But I've got one question for you, more interesting. So we talked about family members, which are straightforward, grandfather, mother, sister. But what I think is difficult for most people is where a best friend who has given you 100 likes on your Facebook applies. And where do you draw that line? It could be a former colleague, it could be someone known to you. Where exactly is that line?
I mean, brilliant question. That's why we lawyers always get work, because sometimes there's no black or white. It's all grey, And then you come to us and they will charge you a little fortune. No, just kidding.
No, we
thank
don't.
goodness for Project Law Help. We don't. Project Law Help does it on the pro bono basis. But good point. Now, there's no clear line. What if your friend? What if your best friend? What if your third cousin, your fifth cousin, or whatsoever? Now, the best guide is this. I always feel. Now, if you feel that there's a possibility of conflict of interest, right? You just feel. I mean, it's sometimes this little sixth sense that you have up there that something is not quite right. It doesn't sit quite well with you at night. You can't sleep over it. Fine, declare, and step out. That would be the best advice I would give you.
Yeah, so actually on that point, because conflict of interest, right, there's no bright lines. You will often find that some situations are very clear, it's black and white, but there are a lot of situations where it's not so black and white. So one of the things that I also wanted to highlight was, what is the general principle behind a conflict of interest? It's good to know that as well. So when you're in a position where you're not sure, then you apply the spirit of the rule. You always have to do what's in the best interest of the charity. Not always, sometimes it's easier said than done. Okay, so
I think another probably pretty useful is that if you were to come into an issue of possible conflict of interest, you're not too sure about it, does Project Law help? Right? Drop them an email, give them a buzz. It could be just a one-liner quick answer or a very short answer. and that's why we are here. There's a reason for us to exist, to help you.
Yeah, and that's true. Call us. We are very happy to help. That's what we're here for. That's our purpose. Our purpose in life is to help charities. Okay, so come to us. Okay, so then that leads us to the next point. Since we are in a governance week, right? So we should talk about governance. And part of governance is clear policies and procedure. And I think all of our participants here, based on the feedback and the questions that have arisen, you guys are very well aware that you need to have some kind of guidelines, policies, conflict of interest policies or COI policies in place, which helps you to prevent a conflict of interest situation, manage a conflict of interest situation. Okay, so does everybody here already has a COI policy? If you already have, then we can just skip this whole section.
Okay.
Anybody?
Who has a conflict of interest policy? Okay.
Anybody still working on the conflict of interest policy or thinking about putting one in place? Don't be shy. No, everybody's got one in place, yeah?
I mean,
Well, it's good to, I think, because what we wanted to cover, and this might be useful for for charities who actually already have a COI policy. Maybe you just cut and paste it from some standard form somewhere, and you might actually need to tailor it to your particular situation. And so we just wanted to highlight some of the key elements of an effective COI policy. And these I think are the key elements. Your COI policy must be able to identify the conflict at an early stage. So one of the ways in which you can identify a COI at an early stage is, as one of the participants suggested, you have a standard procedure before every meeting, whereby you ask your board members to declare if they have a conflict of interest. Usually, you would have had an agenda circulated. So at the beginning of the meeting, make it a standard. Declare. If you have a conflict of interest, declare. Say first. Yeah, it's never too early to identify a COI. Sometimes you may even go behind. Even before that. And your policy may actually say, when you're actually hiring somebody for a position as a board member, as a senior staff, or whatever it is, at the interview stage, ask them to declare whether there's any potential conflict of interest. If it's a situation where a conflict of interest is going to arise very often because of the connections or the background of this person, then it might be something that you need to take into account in deciding whether or not to go ahead with the appointment. And then you should also set out the procedures that can be taken to prevent the conflict of interest from affecting the decision making. And this one, there's no one size fits all also. This one sometimes you have to look at the situation. How serious is it? How serious is the conflict of interest? In terms of what kind of measures you take. Because apart from declaration, abstaining, sometimes in a very, very serious situation, conflict of loyalty, say, and the board member is in a position whereby both his charities are bidding for the same project, you might actually need to secure his resignation. Those are serious cases. Or some situations you might actually need to think about, say, getting a formal view or advice on the situation, a third party input on how to resolve a particular situation. And then lastly, an effective COI policy should also adopt a system for formal recording of conflicts of interest and how they were handled. So, today you have a conflict of interest, you've managed it properly in accordance with your COI policy. Make sure you have a record of it. It's important for transparency because for charities, right, it's so sensitive. you need to not just be transparent, make your COI policy available, but you also need to be able to explain your decision making to demonstrate that you have managed a situation and there is no that the best interest of the charity has been protected in the decision making. So always have a record of how conflicts of interest are managed.
So if you need a law society or the project law help to help you, I think this is a brilliant point where you can engage them and say, hey, perhaps help us to draw up a conflict of interest policy for your organization.
Yeah, because the thing is with different charities, different kind of scenarios, potential scenarios can arise. You want to make sure that your policy is detailed enough to be able to cater to as many situations as possible that might possibly come along the way for you, so that you avoid a situation where too many situations where you completely don't know what to do. There's nothing, there's no policy, there's no guideline, and so that's one of the situations that calls for tailoring, and with tailoring, we can help you if you need to speak to a lawyer to ask them to draft your COI policy. This is one of the areas that PLH can and would be very happy to help with.
Let me throw just one more question. We know that in the charity sector it's actually quite small, and in Singapore you have people sitting in various charities, people sitting in wearing multiple hats. So conflict is always around the corner. Now, any of you have any issues where your paid staff or paid executive is also a board member of another charity? Anyone? No one. Okay. Do you think there's any conflict
There was
if...
someone.
Sorry?
There was someone.
Oh. Yes. So do you think there's any conflict of interest in such a situation?
I was going to ask a similar question in terms of how do you deal with conflict of interest? And now maybe explain this and then share this, how we deal. So I think a lot of people are thinking in terms of, the last point you talk about recording and having to do this, how do you do that? For us, what we normally do is always tabled at the board meeting. And it's always, so it has to be tabled at the board meeting, discussed at the board level. So it's not about just an email or just one person's talking to the other. It is never done that way. It always has to be tabled at the board. And I think this is something that I will share from our perspective. And in that respect, it's always highlighted at the board level. I said, okay, I'm also sitting in this charity, and we're also doing this. But given the fact that, so we just, conflict of interest, it doesn't mean it's bad. I think a lot of people say conflict of interest is bad. I disagree, because I think there's a lot of good for us even to work together collectively, because I think we want the transfer of learning from one board to the other. It's not bad. I think we just need to be transparent. I think the issue is not about it's not a good or bad issue. I think the point is that, are we transparent? Are we communicating? How are we doing that? And what processes do we have in place to do that? And that's part of my sharing. Thank you.
Okay, so back to the earlier question. Anyone with a paid staff in one charity and being a board in another member of another charity? Anyone? No one. Oh, yes. Do you think there's any conflict? Oh, sorry.
No, there's no conflict, because it's completely different. We deal with different things. One is the elderly home, the other one is addiction treatment. So,
Okay, excellent. What if it's in the same industry? Anyone? Do you think there's conflict?
yes, then it will be.
Why so?
Because if it's in the same industry, there will be times where you have to decide. You're a paid staff, so where you are paid, that priority comes first. So then you should not sit on on the board of another same organization, I think, unless you can be absolutely subjective and transparent, which is difficult, I think.
Brilliant. Actually, you don't really need lawyers. You got all the answers. True. the problem is that when you're paid staff and then you're sitting in another charity, you will find that it's going to be very difficult to manage that conflict, because you get information on both sets of a charity which may be pitching for the same project. And as much as you want to say that, look, I don't want to partake in the decision-making process, but there will always be this concern that as a paid staff, you might be misusing the information. I mean, as much as you would like to declare, right? But you don't. So at the end of the day, the key thing is that you try to avoid such situation, if possible. Would you like to comment on this?
I think obviously the best part is to, I mean, I think in the ideal world whereby, you know, I mean, there's no conflicts, I think that it's right. But I'm of the other opinion. I think here is our opinion about managing situations. I am the opinion there's no right or wrong. So I believe that conflicts of interest, if they are managed correctly, we see this in listed companies as well. You have boards who actually recommend that. That doesn't mean that if you know someone who is doing well, who is able to contribute that, and actually that person is actually going to give you at a lower price. It doesn't mean that that is is bad. But so long as if you are the person who's conflicted, you're staying away from that decision making. Identify that conflict, step out of the decisions, so that that discussion can take place independently. I think that's the way I see it. Is about the process you put in place to ensure that you minimize these conflicts when those conflicts take place.
Thanks, Richard. I guess the key point is, what are decisions where you can step away and not be part of the decision-making process? And what are situations where, unfortunately, you're in that position, the information you receive by virtue of being in that position creates a conflict? So this is the part where it's actually a very fine line to draw. I mean, again, if you have any doubt, there's still the Project Law Help in the Law Society. They'll see how we can help you on it. Yeah. Okay. We are going to run to perhaps our third topic, or is there anything else you wish to cover?
Just before we go to the there was one more question.
Sure.
Cyril, sorry to belabor the point. My name is John Teo. You mentioned just now that $5 example, right? So if you say that even though the $5 is below market value, try to avoid. So in a situation where there's sale and purchase of services between two charities, they are somehow related but different entities. So to protect the board of the buying entity, what must we do, for example? So even though we have to go and get a couple of quotes to make sure, and sometimes the services could be quite specialized. It's not easily so you can get 3 quotes, you know. And what circumstances must we do? Some gentleman just now mentioned that we must go to a board, make sure a board discussion. No? But if this were a normal purchase, which one of the subcommittees like the finance committee can approve, does it mean now it has to be elevated for a board meeting to approve? Thank you.
I think when there is a potential conflict of interest, it's best to elevate it to the board level. Now, I do sometimes understand how absurd it gets when we have, I won't mention names, but I remember there was where once we had to have one organization, we needed to get Dick Lee to entertain, because some donors wanted Dick Lee, right? And then we were wondering, like, how are we going to get 3 quotes? Open a directory. Okay, Dick Lee, Richard Lee, and Dickie Lee, right? I mean, how do you do that? Sometimes, there's only one. There's only one person that you want, right? And for that purpose, when it's a very specialized service, I mean, that's a good point. That's a clear justification to deviate from the norms. But as always, if you feel, or at least your sixth sense feels something is not quite right, or your stomach doesn't feel good about it, escalate. Right.
Any other questions on conflicts?
So I just have one question. I recently had a board member that was promoted. I am an operations guy. I'm not a board member. And we work in a volunteer organization. So we are a company that's registered and it's limited. But the issue that we were having is that her husband is a head of department for one of our things that we're doing, and was not reporting through me at the time, who I'm currently the head, like the top operations guy. He was reporting directly to the board. So when she was promoted, any decisions made at that point to me and the people who were under me seems as a conflict of interest. Is that correct? Yeah. Okay. So what we did to mitigate this was I proposed to the board that he no longer report directly to the board, that everything that he does has to go through the channels through us. Does that mitigate that, or is there still a conflict of interest?
I think what you're actually looking at is a potential conflict of interest, not really, not necessarily a conflict of interest. So you're right to say that you need to have procedures in place to mitigate the situation and to avoid a real conflict of interest from arising. I think what you suggested is...
It's not so much financial conflict of interest as much as like what's best for the organization.
Yes.
Because if organizationally, if we have a certain direction we'll want him to go, but he disagrees, he can just go straight to the board, and then he has an ally always.
Mm.
So that's where we had this thing where it didn't seem so objective.
Mm-hmm. Well, it sounds to me, if a decision comes up to be made by the board, and one of the board member, in the situation that you've described, is not completely objective and can be swayed by another person, then the board member, might be in a position where she or he cannot be objective and to make the best decision for the charity. So we go back to the kind of steps and procedures. How do you manage that kind of situation? You had declaration. You had, the board member, that particular board member recusing herself from the meeting, stepping out, not being involved in the discussion, not voting. Yeah, those are the kind of things that. Yeah. Yeah. Yep. Good. Okay, if there are no other questions, just one parting note on conflict of interest is that, so all of you are familiar with the COG, and the COG actually has a section on conflicts of interest. And the section on conflict of interest is actually the same from basic tier through to advanced tier. So, it demonstrates how fundamental this duty is. And I think you will also probably know that the Charities Accounts and Annual Reports Regulations has been amended. So with effect from 1st of April 2018, you will be expected to file your annual return together with a GEC, the Governance Evaluation Checklist. And you'll find the checklist appended to the COG. You need to identify which checklist applies to you, and fill it up and file it. And it's filed on the charity portal, so it's available for public viewing. So if there's any questions on the GEC or the COG or the PIE or the AYE, again, PLH. All right, so the next section, we are going to, which is the last section, is the protection of personal data, PDPA. Cyril, do you want to take the rostrum? Because this is Cyril's the expert on PDPA, and he'll.
Okay, sure. Okay. Now, the PDPA was came out in 2012, right? And this becomes, again, a burden for charities who got to also comply with the PDPA. Now, I won't go through the entire PDPA, but I just want to pick out little points, little pointers here and there, which and try to create little illustrations, examples, where I hope it's useful for the charities. So I won't cover all the obligations under PDPA, but I would like to cover a few, like the consent obligation. Now, how many of you install CCTV cameras in your counseling rooms? If you're running a before after school care service, do you have a little camera somewhere? Hands up, anyone? Okay. So the question is, you'll be recording your clients, the children, whatsoever. Do you get consent from them that you're doing the recording? Yes? Sorry? Okay. So you have the signage. Okay, good. So you complied with the notification, right? The notification provision saying that you have a CCTV camera. Now, your notification would need to state the purpose of your recording, right? So that is actually that's one point which I wish to cover. Now, notification would also include not just like where you are having a camera inside your before after school care or your counseling room. It could be because perhaps the center has has this issue of burglary or people fighting outside. So you install a camera outside your center to just see what's happening around. You know? And even when you do that, even for security reasons, you also need to put up a sign, a notification outside the center saying that this place is being monitored by a CCTV camera for security purpose, right? So these are some of the regulatory requirements that's been imposed by the PDPA. So let's take another example. What about you have an event, you organize an event and, sorry, yeah? Yes. Okay, sorry, whether the...
If under each camera you have to have the sign like this is CCTV under surveillance because of security and so on and so forth, or does it's enough at the entrance somewhere at the school? I come from a school, so it would be interesting to know if we have to put it everywhere or just at the entrance where people or students arrive.
Well, you put the sign at an area where whoever who goes past the area and who might be captured by the camera. So you have a school, for example, and you have multiple cameras all around the school, but the people only pass by through your entrance. So then you can just have a sign at the entrance say that the school premises are being monitored by a CCTV camera for security reasons. That's good enough. But if, yes. Yes, then you have 3 signs. Then you have 3 signs because you have people coming in from 3 different entrances. Right? Okay, so that's the notification provision. So now let's say your school, and okay, there's a bit of feedback here. And you have an event, and what you like to do is you would like to have someone to video the event, and then you upload it to the Facebook to show your event. Now, do you need consent from people who attend your event and allow them to agree to be videoed and put on Facebook? What do you think? Yes? Okay. Yes, you need. Yeah. And we find that a lot of charities, they don't do it because, yeah, they just either don't know about it or you want overzealous social worker or member who that, hey, this is nice, let's video, and they just video it on their mobile phone, upload it on Facebook, and count the likes after that. Now, that would be in breach of the PDPA. So even when you were to do a recording of such, you should technically get the consent of the people attending it to be allowed to be videotaped. Yeah. you can do that. That will be by notification, right? And the concern is that when they may not consent to it, then at least you give them a chance to not to come. Yeah. Sorry? Best is written because you want to you need to capture the consent, right? If it's oral, then it can be very tricky because it will be you say and I say. Yes.
In this event for media, if you're going to do notification, does there need to be a clause that states if you attend this event, you are hereby giving consent to be videotaped, such and so forth?
Okay, this is where it gets a little bit tricky because under the PDPA, you cannot exclude services if they do not give you consent. So that's where you get a little bit of problem, right? But assuming it's an event and you're telling people that you're going to record it, right? And you welcome everybody. This is where sometimes common sense must prevail. If you have an issue of yourself appearing in an event, then don't come.
And then my other thing is if you have written consent and you have say a mass photo of an event, say it's a concert, 10,000 people, but you have one person who didn't consent and they're in that mass of people. At that point, can you not publish?
Okay, so this is where you try to be. You try to be pragmatic about this, and should the commissioner will come after you say, look, we've got everyone consenting except for one person, and it so happened that person over there, and you can't really see his face very clearly, and it's practically anonymous, and let's see what the commissioner says. So I don't think that would be an issue.
Excuse me?
Yeah.
For the ATM machine, they don't need a notice, correct? It's for your own security.
Now, technically, they should have. I mean, if you were to see the camera pointing at your face, there's a clear notification that you are being monitored, right? And it's also for your own security. So the next question is this, right? Sorry.
So for internal staff consumption, because if you have like a big organization and different facilities, so when event happens and you take pictures of like the beneficiary, but really for internal circulation, not for external newsletter, do you still need to seek consent?
Yes, you still need consent. Yes, you still need consent. Because the person, your beneficiary, may not consent to himself being video captured for whatever purpose. Unfortunately, you still need consent. Sorry? Okay, so if you are going to video your staff, say you have this working area and you have a CCTV looking in, and you need to at least notify your staff that you are being captured on video for whatever reason, and it must be for a legitimate reason. So for security, for monitoring, but you need to notify the staff. You can't do it surreptitiously. Oh, take the video of the beneficiary but only show the staff. Yes, you still need to. You still need consent from the beneficiary. Okay, so the next thing I'd like to highlight is purpose limitation. Right? Many times you have your when you work in a charity, you have your beneficiaries. You take information, about their family details, about their pay, the means test, and all these things. So you have a lot of data of your beneficiary. And when you take these data, you must always let your beneficiary know that it's for a particular purpose, that is to facilitate the delivery of your services. So if let's say I'm OKFSC and I have data of my beneficiary, and I look at them like, hey, I think this group of beneficiary would be, they would also be interested in, say, another services offered by another FSC or another senior activity center, can I then transmit this data to this other senior activity center and so to allow them to contact my beneficiary? Can I do that as FSC? No, right? Unless, yes, unless they consented. Right. So these are quite basic. Now another key thing is accuracy. If you collect data, you need to ensure that your data is accurate. So when you collect, when you fill in the names, the marital status, the pay grade and things like that of your beneficiary, you need to make sure that whatever you fill in is accurate. And if there's any reason they find out that, look, you got my pay wrong, and if with this pay I would fail all means tests, right? They have the right to tell you, please correct the data, right? So you know about that. And another point to that is you should not be holding the data beyond what is necessary, right? So a good point would be your staff data. How long do you hold on to your staff data, your ex-staff data? Anyone? How long does your organization hold on to your staff data?
I'm a finance person.
Okay. So it could be, I got 6 years, is it? Okay. Anyone else? Any information? Anything? How long do you hold on to your staff data? Seven years. Okay. So a lot of times, even not just in charity, but in the private sector, you hold on to ex-staff data because that's a super staff, that's a terrible staff. Don't ever hire this staff. When they come back. So now under the PDPA, you can't hold on to even your staff data beyond what's a reasonable period. And I have to check, but I believe it's 3 years, right? Yeah, because. What reason do you have to hold on to staff data beyond 3 years after the staff's employment, right? For the same reason, you have your charity, your beneficiary, you can only hold on to their personal data insofar as it is still relevant and it's reasonable, and it's a reasonable duration.
Cyril?
Yes?
Can your beneficiary or the staff come to you and say, please delete the information?
Yes, they could do that. If it's no longer relevant, they can come to you and say, look, you have no business holding my data. I'm not going to come back to you anymore. I absolutely do not like your service. Please delete all my data. And they could do that. They could do that if you have no longer any legitimate reasons to hold on to the data. Right? Yeah. So that deals with the retention limitation.
Sorry, I have another question. So you said that one of our obligations is to ensure that the information that we are gathering is correct. In light of the new rulings with the PDPA, where you're not allowed to just anyhow take NRIC card and all of this information, but especially for some of the things that we do, we deal with students and different things like that, and I have volunteers. We find, there are certain provisions where if it's deemed necessary, for me it's deemed necessary because I need to make sure my volunteers aren't pedophiles, or something else, But that's for one part of it. But also for beneficiaries, we need to make sure that they are who they say they are. So where's the line drawn? I understand that, there's some people just taking it because, got membership, want to use their NRC number for membership. But where's the line? I've read this stuff, but at the same time, it's still a bit blur.
No, good point. It's how you could reasonably comply, right? And if someone were to come to you and say, my name is Cyril Chua, I'm 47 years old, and you made a mistake, put 37, then you have a duty. If I were to come back to you and say, look, you got my age wrong, then you just need to make the revision. Yes, you just need to make the revision. But there isn't a positive process where you need to verify, check the date of birth, check the NRIC to make sure that all data is correct. You have to rely on your beneficiary coming to you and giving you the data and making sure that, to your best of your ability, that it's correct. So assuming that someone will come to you and say, this kid come up to you and say, my name is David Tan and I'm 47 years old, and you look at it, that cannot be true. But if you were to go on and put 47 years old, clearly you're shutting a blind eye to data which is obviously not correct. So there is no positive obligation for you to verify all the data to ensure that they're absolutely correct. But you have to take within your reasonable means to ensure the accuracy of the data.
Sorry, does
Sure.
data include photos and videos?
Yes, it does.
So for staff who have resigned more than 3 years ago, you can't keep their photographs or videos or publications of, you know?
Okay, I think, well, I mean, here again, you have to draw when you need to draw a line and be reasonable. I do not think that the commissioner will expect you to redact all your staff picture from all your database, you know, your magazines. No, I don't think that's the expectation. But I think the expectation is you would keep a staff of your file, right? Sorry, a file of your staff, and you have no use for that file or the information inside, then you're expected to erase it. Yeah. Mm-hmm. Yeah. Yes. So they can't force you to erase or redact the picture of the staff, but because that's part of the history, that's part of your magazines, right? But let's work within what's reasonable, and that is if you have a P file of your staff, so long it's no longer useful, then you have to remove it or delete it. Yeah. So another key point is after you have collected all this data, what you need is to protect the data too, right? Now, you have seen many data breaches, and the problem with data breaches is that's when the commissioner come in and look at it. What have you done to protect the data? Because assuming that you have a list of all your beneficiaries in your society, and those are actually, well, very valuable data because people may want to know who are these people, or even your list of donors, others may be interested in getting such information, and you need to protect your donor information, your beneficiary information, and you need to have a process or a policy on this. Now, what the law recommends is you should have a data protection policy in place, and you have also a person who is the data protection officer in your organization. Right? Now, the data protection policy is something that you can, in the event of there's a data breach, it is something you can always rely on in saying that, yes, we have a data protection policy, we comply with policy, but unfortunately there are a bunch of Russian hackers who are really good in the job and they hacked into my system and they took my data, right? As opposed to you have a situation where you have all your sensitive data and then there is a data breach and then the commissioner come and ask, so what have you? I said, oh, well, I mean, we put all our beneficiary information in this shared server and they ask, oh, who can access? Oh, any staff can access. So do they need a password? No, you don't need a password. Even the tea lady or the can just turn on a computer and pluck out this Word document file from the shared server. And that's when you have trouble. You have trouble because you don't have any process. You don't have any process that protects the data, right? And not only that, you need to have a sufficiently robust data protection mechanism. The more data you have, the more sensitive data you have, you may need to look at different levels of password protection. So say you have all this data and you say, look, I have a password. For you to have access to this data, you need a password. Then the next question we'll ask you is, so who gets the access to beneficiary data? Would your receptionist have access? And then if your answer is, oh, actually, any of my staff can access to this data, because they all have a password that allows them to enter their email. If you enter the email system, then they can have access to this data. Then the Data Protection Commission will ask again, do they need access to this data? Does your receptionist, your tea lady, or staff or your admin staff, do they need access to your beneficiary data? If not, then you are not protecting your beneficiaries' data. So you need to figure out a system where these data should only be accessed by your staff who requires access to this data. Right. So I've covered basically consent, purpose limitation, notification, accuracy, protection, or retention or limitation. Any other questions on the PDPA?
I have two questions. The first question regarding the retention limitation that you mentioned. Does it cover only staff, or does it cover also ex-board members, volunteers, any stakeholders that deal with the organization? And the second question is that what kind of information can organization ask? Because, for example, medical record is confidential, right? So what kind of disease that you have had in the future? So I saw in the volunteer application form, for example, asking for past medical history and also past criminal records that could like have a stigma, right? So can organization ask this kind of confidential information? That's all. Thanks.
Okay. For the answer to the first question, not just employees' record, any personal record, right? Personal record of your beneficiary, of your donors, your directors, so long as they're no longer relevant, it has to be removed. So when I talk about ex-employee, it's merely an example, a class of people. So when you were to look at it, it's any form of personal data. If it's no longer relevant to your organization, you're advised to delete it. So the next question is, when an organization were to ask records, medical records, criminal records of, say, a volunteer or a donor, are you at liberty to ask for such information? Now, you can always, first of all, you can always ask for such information. Is whether the discloser is prepared to disclose the information. And secondly, if you should ask for such information, you should have a legitimate reason to ask for the information. So, for example, you're in a children's society. Is the children's society around here? No. Okay. Say you're in children's society and looking for volunteers to take children out for outings and trips, and obviously you like to know that do they have a criminal record, right? Are they, for whatever reasons, and that would be a legitimate reason to ask questions of such. And again, it's up to the person to disclose or not disclose. And if they wish not to disclose, then you say, I'm sorry, you can't participate in this activity. Sorry.
Yeah. I just noticed that we have a photographer running around taking photos. So I'm just interested to know if SIAS has indicated for our consent to be photographed.
Do you get permission? Okay, well done. Okay, so we shall ask SIAS after this. Okay, thank you.
But my company is actually an event organizer. So what would be a good practice? You know, if I have a photographer running around, should I be flashing it there to say up front that, look, guys, I'll be taking photo of you guys? Is that a good practice?
Yes, that would be a good practice. I think the best practice would
Really
be
upfront,
before they enter the event, they could sign something to say that they consent to having their photographs being taken. That would be the best practice, right? Now, of course, there'll be people walking in and strolling in, and they look at it, oh, this is, la-di-da, I'm not going to sign it, and just walk in. Then the best thing is, before the start of the event, just flash it out and say, by way of notification, that you'll be taking videos. Okay. Sure.
You made mention earlier that we cannot refuse services to people based on PDPA, correct? She had just brought up about volunteers asking for medical and criminal record. I do this in my volunteer forums because we deal with people that are vulnerable, whether seniors or children. If I have then a volunteer who is not willing to disclose or wrongfully discloses this, according to at least beneficiaries, I cannot refuse them. But according to volunteers, can I refuse them legally?
No, you can refuse them legally. Now, I'll try to give the example of non-refusal of services. So, assuming someone comes up to your charity, say an FSC, and they're asking for maybe they make an application under the milk powder grant or something like that, right? And they have to fill out the form. And in your form, you can't put that, or by filling out this form and participating in the milk powder scheme, you consent to us disseminating your information to all the milk powder companies and this and that in the whole world. That's not right. So the beneficiary may say that, look, I'm applying for this scheme. I'm prepared to give my information solely for the purpose of the use of this scheme and not for you to cross-market, to disseminate my information, for outside the purpose of my intent. So again, the same thing. I mean, if someone were to apply to be a volunteer in your organization to do something that might be sensitive, perhaps to take care of the children, you need to check whether they have a criminal record, are they a pedophile or something like that, and you have to get them to disclose. Okay, so how about this? Assuming that you're a huge charity and you have lots of volunteers and you have lots of beneficial information and you want to make a study, a case study, or not a case study, but you want to look at the trend, your service trend, and you want to look at statistics of your service trend. Can you use all this information in your study? Yes, no?
Sorry? It's
I heard someone
purpose
saying
limitation, right?
Okay. Assuming you didn't get a consent from the beneficiary, but you need to use such information to conduct your studies, what should you do? Yes, anonymize the data. So remember, so long as you can use the data for your study, so long as you anonymize it. So the key thing is this: it doesn't mean that they didn't consent to it. You can't use it. So long as you sufficiently anonymize the data to make sure that the data taken could not be identified with any individual, then you can use the data. Okay? Yeah. Yeah. Any other questions? Okay.
Just a clarification. Some time ago, I think we all watched a video in the internet about an abuser abusing somebody. Okay, if I was the one who was taking the video, have I committed something unlawful and published into Facebook?
Okay. So, good question, right? Now, what you're talking about is, say I walk out and I see two persons fighting, right? And then I take a video or take some pictures, click, and right? And then later these two fellows are fighting come out to me, hey, this is under the PDPA. Right? You can't take my picture, you can't put it on Facebook. You know what? I don't have an answer to that. I'm so sorry. I mean, it's a very simple question, but I don't have an answer to that, and I need to go and check it out. So I'm sorry, not all lawyers have answers immediately, but I will come back to you on this. And that's how the Project Law Help works. We don't have all the answers, but we'll come back to you. So if you give me your name, I'll come back to you.
This one, I'm sure you have the answer to that. So say we have like an internal human, what do you call a personnel directory, right? And then, so every staff has actually a photograph attached to it to facilitate searching online, internal intranet. So if a staff come out and say that, well, I didn't give my consent, and therefore you cannot put my picture online in the intranet for people to search me, I mean, that doesn't sound reasonable, right?
You need a picture and you need the name, and it's all for a particular purpose, right? So you look at it, purpose limitation. Someone were to say, okay, I give you all this information, and you use it, you probably have in your employment agreement that, or at least by implication, that this information will be used for searching and for directory purposes. Then it's very hard for the staff to say that, hey, that's not reasonable. I didn't give you this information. Yeah. But the best thing is always have a data protection policy, right? So this is actually to protect you, to safeguard your organization. In the event of a breach of data, right, you can always go back and rely on your data protection policy. That is provided you make sure you comply with your own data protection policy. No point having something and stick it out there, hey, I have, but no one actually listens to it. Then the poor data protection officer will get it big time from the commissioner. Anyone? Okay.
Just now you mentioned that the PDPA says that for employees you can only keep up to 3 years.
I believe it's 3 years. I need to check again.
Yeah, because it's a bit odd, 3 years or 5 years. But I have instances where after 5 years, 6 years, some HR wrote me a letter saying, does this employee ever work in your company? That if I've destroyed all the data, I wouldn't know whether this is my employee or not.
So the first thing is, who is this HR company? I mean,
When this ex-employee applied to another company, then the HR will come to me for reference.
yeah, the question here is that, are you even at liberty to disclose whether this employee worked? Unless it was this employee who instructed the HR company to come back to you for reference. Okay. Well, then you can just say that you don't have the record anymore, right? Because of the PDPA, we have deleted the records, and that's all well and fine. Yes. Well, but the key thing here is you do not need to keep records beyond what's needed. So what you can do is this: you can keep a record of the name of who you employed, but you can't keep the P file because there's no reason for you to keep a P file. Yeah, yeah, insofar as necessary. Yeah, but you have there's still a justification to keep a record of who you employ, right, as a name. But really, there's no justification to keep the private file. Okay.
Does the PDPA protect information belonging to companies or organizations?
Personal information.
So only individuals?
Yes, yes, personal information. So if you're talking about trade secrets and whatnot, that's protected under the common law of confidential information. Okay, any other questions? I promised the hotel that we release the room by 4:15, but I'm sure we could take 2 more questions if there's any. Or even for Juliana on the earlier points? Okay, we'll take one there.
I want to ask about the first issue. Under CLG structure, what is the members and governing board members? What is the difference in the roles and responsibility? Especially if the CLG only has one corporate member. So there's one corporate member and there is also a governing board. So what is the difference in the role and responsibilities?
Under the charities regulations, all charities must have a governing board. So you have to have governing board members, at least 3 of them. Any other officers or roles that you have within your organization apart from these, or any overlap with say these board members have dual roles, that's something that is up to your organization to dictate what they do, what is their scope, and things like that.
So if there's some, say, mismanagement, so who is responsible for such things? Is it the board, governing board, or is it the sole member?
Well, you have to actually then identify what is the issue of the mismanagement, what is the subject matter, and then relate that to the responsibility of the respective person in order to find out who is actually responsible for the area.
So can I say generally it is the governing board that is responsible for the management of the running of the charity?
Well, the governing board has a very wide role, including the management, primarily the management of the charity and making sure that its objectives are reached. So anything that comes within that purview, potentially, if it is not managed properly, you might be able to hold the board responsible.
Okay, thank you.
Maybe just to explain a little bit further on the same point. Now, the governing board is the board of directors. They make all the decision, the working decision of the charity, a policy decision. The member is the person who holds the liability. So it's a CLG. He guarantees up to $100 of liability. So that person who signs off will guarantee that liability. Now, at the end of the day, if let's say the board has been negligent or any particular member who has done something wrong, that particular board member will be liable for either breach of fiduciary duty or something like that. And not the member. Okay. Any other questions? Okay, we'll have the last one here.
Just want to ask also, when in recruitment of position, right, especially senior position, there's this common practice that we might ask for reference from the previous employer. So with the PDPA, does it mean that it is inappropriate to ask already nowadays?
Good point. I never thought about it. But if I think about it, yes, it probably would not be appropriate because unless there is consent. So let's say I were to be from, what's the charity again?
Change.
Change. Say I'm in Change, right? And I want to apply, and I just got fired because I've been negligent in my duty. And say I were to apply to Ang-Mo-Kio FSC, right? And I put there previous job, Change, right? And if Ang-Mo-Kio FSC were to contact Change and say, so how is Cyril? Was he a good employee? I don't believe that. I believe that he Change would not be able to answer to Ang-Mo-Kio FSC without breaching my PDPA. It's the PDA provisions. But if, let's say that's not the case, right? And I've been a stellar employee in Change, and now I'm going for the executive director job in Ang-Mo-Kio FSC, and I said, well, you could always contact Change to check my credentials. And I've consented to Change to release the data to Ang-Mo-Kio, then that's not the problem. Yes, that would be personal data. My performance records would be my personal data. Yes.
Then would it also incur more problem in terms of, like, let's say if this employee really has some particular problem in the previous employer or in the previous employment, not pertaining to criminal kind of thing, but it could be some sort of flaws, then, how to prevent that?
Well, the key thing is this, right? If someone were to ask for a character reference of an ex-employee, the ex-employee must consent to the organization to release its data. So, okay, assuming I'm in, say, I applied to Ang-Mo-Kio FSC, I was previously from Change, and maybe I was previously from Marine Parade FSC, and I did a good job in Marine Parade, but I did a heck of a lousy job in Change. So I put Marine Parade FSC as my referee, and I left out Change. But in my CV, there's like, okay, I spent 2 years in Change. So they can, by reason of me putting Marine Parade FSC as my reference, it's implied that you can contact Marine Parade FSC to verify, right? But if Ang-Mo-Kio will say, hey, he didn't put something about Change. He didn't put about his time in Change. Why don't I call up Change and see what happens? Now, Change would not be able to release my performance records to Ang-Mo-Kio. Okay.
One question here. Regarding if you want to be legal entity, their way is ACRA, trust corporations, or ROS. So if organizations who did not even with ACRA, registered with ACRA, ROS, or as a trust corporation, but they listed with COC. So is this still a legal entity? But banks still accept this organization to open a bank account.
So it's not a society, it's not a trust,
It's
and
also
it's
not
not a company. So what is it then?
They listed with COC as a charities.
Wow, how do you go about doing that?
Maybe
think-
old time, at the very old time when the first when the COC first set up a time.
Okay.
Interesting. Well, I think you must be something. You just don't know what you are. You can't be nothing. Yeah, because the Charities Act, which is the main piece of legislation governing charities, it actually doesn't say that you must be a company or you must be a society. It actually, provides you a blank canvas. It can be
I'll get back to
any
you. Okay.
organization, whether incorporated or not incorporated, any institution. An institution can be a trust. It can be any undertaking. So you would be something.
Yeah, because you need to have something to register, you need to have even at least a minimum a society to at least do something. If it doesn't exist altogether, it might be a trust, right? It might be formed by a trust. But it's a very interesting issue, but let's look at it. There are sometimes things that falls through the crack, I used to look at, say, the SPCA. They're a member of NCSS, and you kind of wonder the SPCA. So does it fall within the children's side, the disability side, or what side of it? And I was told, it's actually historical. So a lot of things could be historical, and unfortunately I don't have an answer for you on this. Okay, thank you everyone. I mean, I had quite a fun session, and I'm sure, Juliana, you have any closing? Yeah. So remember, the thing which I really want you to take away from today is 3 words: Project Law Help. You need anything, write to Project Law Help. Juliana will be able to assist you. Thank you, ladies and gentlemen.
Ladies and gentlemen, could you please give that a round of applause, please? Thank you very much for having Cyril and Juliana. And before they leave, we'd like to give them a token of our appreciation and show them our appreciation. We have that. Can I just have something here? And if anybody wants personal discussions, they will still be around to take your personal message. I know a lot of people don't want to share their insights over here, so they will be still around to just take one-on-one questions. Thank you very much, and please remember your forms. Please, we do need them. Otherwise, we'll have to send you a check for the rest of the bill. Please, your feedback form, please. Thank you very much, and we'll see and have it outside. I think we do have some tea break also. You don't have to run straight away. You have some tea break upstairs. Thank you.